Шановні пані та панове, ми зібралися тут сьогодні у різних просторах.
During the accession process, the pathway that we go through as a state, and the human rights are important for that. So, some logistics. There are going to be two parts of our event. The first, that is the presentation itself of the map, and the second part is the discussion that you'll be able to take part in. Coffee breaks are there behind in the hall, so you'll be able to take some coffee breaks as well. And some security measures. In case of a raid alert, we can choose the most appropriate way for us to follow. So there are two options. We stay during the air raid alert, and the second option, we should go to the shelter, but it will take some time. Please raise your hand if you are ready to stay during air raid alert. Yes, I believe the choice is obvious. So in case of a raid alert, we stay here. But if you need to go to the shelter, this event will be recorded. This event is funded by the European Union, and the content is presented by the Center for Civil Liberties and does not reflect the position of the EU. And I would like to give the floor to the person that has contributed a lot to this event, Elena Matvichuk, the head of the Center for Civil Liberties. Thank you for all the participants that you came here, as that is an important event for our team as we present the results of the work, as our Center for Civil Liberties has been working for a year and a half. And I would like to recall the year of 2013 when we created Euromaidan SOS on the basis of the Center for Civil Liberties, as there was the refusal from the state of the EU accession. There was also the meeting from the students and some prosecution processes for those who participated in those processes. And we all remember the price people in Ukraine paid to follow this pathway for Euro integration, for the EU accession. And I clearly remember when media, when they were asking people why they were protesting, so they started to use the language of the values. As you know, people are unaware of how European Commission works. They are not aware of the mandate of the Commission. So they were stating the values, that they are here to protect the values, as they would like to live in the country where their rights are protected, where the courts are just and independent, and when the state is accountable. So the Ukraine started the official procedure. We came up with the screening, with the roadmaps, with the reforms for state government, for the critical institutions. So there is a huge list of 100 events. I know that is a complex and comprehensive list that is a little bit challenging. We also got some training on that as well, so I understand the complexity. So why we need this map, and why we believe that this map is valuable. And of course, this presentation is not the final point in our work. And both experts and civil activists, both our international partners, they will be able to use this map and to make sure we we talk and we have the component of human rights included in these events. And you can find the state that the EU is about values, and values, these are specific standards. That is why this map helps us to be certain meter to show how we follow these standards. As you know, that's why I recall these events of 2013 as reforms that we are waiting for and the pathway that we follow. It's not that the EU, they need it. We, as Ukrainians, we need this reform. So thank you for the opportunity to, for giving this welcoming remarks. So I give the floor to Volodymyr Yavorsky. Thank you, Alexandra. And thank you so much for taking your time and joining us today. I believe the project that we present today, that is an important thing, not only for us, but for the state as well, for each citizen. As everyone should see, Euro integration is not the abstract thing. Usually when we talk about Euro integration, we talk about economy, some anti-corruption things, and certain reforms in the state governance or some customs activity or Schengen zones, etc. But when it comes to human rights in the context of integration, it is not mentioned frequently. However, that is one of the key components for the negotiations and one of the most challenging components, as it reflects the problems that accumulated within many years. Alexandra started, she already brought this topic. As we have certain tools that are open, these are some interim benchmarks that Ukraine should follow. Also, there are certain obligations from Ukraine when they apply for the EU state member. We have roadmaps and national adaptation plan is there. But again, if we take a look at the component of human rights, so the majority of cases, they will take into force after the end of the war. But we believe that we can accomplish a lot of things at the moment already. We understand the law enforcement specialists have been working in this country for years. We have been involved in this process for 20 years. And our specialists used to work in law enforcement bodies, so we have experience for more than 20 years of monitoring of the situation of Ukraine, and we understand the process that has been taking part at that time. So this tool helps us to implement what we have in terms of Euro integration, but it is also based on the considerable expertise and understanding of the problems that are here in Ukraine, understanding how to sort them out. Ukraine also has a lot of obligation when it comes to human rights. And when it comes to the Council of Europe, there are a lot of monitoring mechanisms. There are committees, and there are a lot of monitoring mechanisms in the UN. But when we started to take a look at these documents and compare them with the reality, we understood that they mention many things that are similar, just using various language. And for the ordinary person or for the politician, to be aware, to understand this tool of this set of tools, it's kind of complicated. That's why we decided to initiate this comprehensive research, as Alexandra mentioned. It took us almost 1.5 years. And today we present the results of this research. This result is not static, so and you know, this is a process. When it comes to the situation of human rights with Ukraine, So roadmap, that is a kind of the interpretation and the breach, between these documents and monitorings and some decrees from the EU. And it helps us to interpret into simple language. So shows us where we have the issue and what we should do with that issue. So there is a key thing when it comes to these tools. For example, as we see the article of the Charter of Fundamental Rights of the EU, it requires certain changes in the criminal code and in other parts of the Ukrainian legislations. So it helps us to reach the level of specific things that should be introduced to the person and what the state should do for the person, not just to follow the formal requirements from the EU. So this map, that is an analytical online tool, and it demonstrates how Ukrainian law and Ukrainian legislation and the practices, whether they are aligned with the EU standards that are also evolving. And sometimes we work on Ukrainian context, but at the same time in the EU, they come up with a new regulation on discrimination, on migration, and on some other issues. So we need to track that. And this tool helps us to track down the obligations from the Ukrainian side. So I would like to share how we prepare the methodological part of this map. So first of all, we conducted such a comprehensive research in the format of policy paper. So that is a document with a policy that defines certain gaps, certain inconsistencies that exist in Ukraine if we compare with the European law, with the European practice. Also, we observed Ukrainian problematic, and we try to identify how it is connected to certain European standards that we need to implement. So each document also contains both qualitative and quantitative analysis. So when it comes to quality analysis, that is a kind of a screening methodology. It is not so that is important for us to make sure we understand what we have to change, what norms should be changed. And the second one is quantitative analysis. So we took a look at the practices, as it is important to see whether this norm in the legislation will work out. As for example, we have the point about discrimination, but when it comes to the prosecution of violence crimes, we can see a huge gap between legislation and what we have in practice. Also, this research shows us the gaps that exist in Ukraine and what can be done to change the situation. This document is based on these 5 things. The first one is analysis of the EU and the requirements and the European requirements regarding Ukraine. There is a gap actually in that regard, and the issues, again, regarding the Charter of the Fundamental Rights in the EU, they have been thoroughly discussed in the Council of Ukraine, and we talk about the same set of the issues, but we should understand that the standards are different. For example, when we took the standards of the Council of Ukraine, and that are there is a list of 100 directives and decisions, so Ukraine should work hard on the implementation of these decisions. So they defined the basic problems that are there in Ukraine. So we took various directives and we observed the reports from FRA, that is the institution responsible for the monitoring of human rights in the EU countries. And we tried to compare that with the Ukrainian legislation. The second step helped us to compare what we found in the EU practices. One of the issues we faced, that there are not many people in Ukraine that are aware of the law of the EU, and we could see a huge gap, and a lot of specialists, a lot of scholars, they are aware of the Council of Europe, but they do not possess enough knowledge about the legislation in the EU and the standards. During the comparison process, we could see certain problems. When it comes to step number 3, we were assessing the current situation in Ukraine. We identified the certain systematic problems in the law, in the practices. And here we focused on the first reports that were produced by Kharkiv Group and the Ukrainian Helsinki community, and a lot of reports by the specialists after 2014. They demonstrated a lot of problems, and we also observed the practices that were there. So we have been working on that for a year and a half, but this map is based on the considerable experience of the violation of human rights. And then we continued our work, and after the analysis and assessment, we started to prepare the analytical policy paper that will be comprehensive both for politician, for the expert, up to 20-30 pages with the list of the issues in Ukraine regarding legislation and practice.
The fifth step is the development of specific initiatives and recommendations. What has to be done in order to change the situation? When experts were preparing the policy paper or documents of analytical policies, then the team started working in that. As we started working in a deeper assessment of problems and recommendations, that's why we had on each institution, you will see later, we have two sets of informations, like deeper research, and we have like a shorter version, which is divided into two parts. It's a list of issues or some discrepancies, what we needed to do, and a set of recommendations concerning what has to be done in the context of that law. It was developed by the NIM, by the Center for Civil Liberties, and we are open for discussion. And moreover, as for today, we are prepared on what is included in that map. We are prepared to implement these recommendations. We are even thinking what we could develop later, what we could support with the developments, and still we are a little bit aside of this process of talking about implementation of those reforms, because this is about more monitoring. We are not in the group of negotiations. We do not represent the government. That's why our position might not align with the government's. I think it's okay, because we are human rights organization, and what we write, it would be useful for human rights. and for each person in this country, because one more time, as it was mentioned by Alexandra, that the process of EU integration, we look at it as a process of transformation of our country concerning human rights. It has to bring useful moments for each person, and we believe that this tool will show better how it might happen. Now I am ready to give the floor to Serdyuk. He's a lawyer and analytic. He was developing on that map. He was doing the researches and he was developing the recommendations. I also want to say that this map is in English and in Ukrainian. It's very useful. You can take it, read it, and it will be always and continuously updated. It's not a statistic or it's not a static document. It's a document which is live, and we look at it as a live online document. Thank you, Volodymyr. I will talk about our map of integration, about its structure. If you open the main page and you go down a little, you will see that it consists of three structural elements, such like topics and the layers, which I'm going to explain step by step. So the first layer is about independent institutions, those institutions which are in the European model have to be protected from political influence. And in particular, if they start losing their independence, if they start being influenced by executive power, then the principles of rule of law will be violated. And what the EU pays attention, the assessment of state candidates, they analyze how independent they are and the level of their effectiveness. In this element, we highlighted such meaningful blocks. It's about Ukrainian Parliament Commissioner for Human Rights. It's prosecutors or general. It's Security Service of Ukraine, as the Central Election Commission, as the essential part for democratic elections. And this sector where human rights can be violated. In each of these blocks, you can see policy papers. They are built in the same structure, and they are created to show what kind of standards can be identified by EU, European Council, Venice Committee, Committee Against Tortures, Committee Against Racism and Discrimination, in order to guarantee the rights. And what the practice of ECHR. Also, we'll talk about how it can be regulated in Ukraine and how it can be implemented in life. What's the national court practice, analysis of statistics, data. Also, we'll talk about gaps between the European system and Ukrainian system, and we will provide a list of recommendations what has to be done now in order to harmonize the Ukrainian laws with the European, and would happen in a better way. It's not a subjective assessment, it's more structural comparison of norms and rights of European and Ukrainian law system. If we go down, we'll talk about the second level. It's about fundamental rights. those basic guarantees which each state candidate has to provide de facto, not just on paper. In particular, you can see a list of such rights. There are different blocks. You can see different blocks of rights, prohibition of discrimination. And when we talk about these fundamental rights, it's not about some article in the Constitution. It's about the article of Charter of EU of Fundamental Rights, Convention, as many decisions of ECHR, which establish the standards for guarantees rights and call to action what has to be implemented in order the country would be in the process of integration and improvement of human rights in Ukraine. If we go down, we'll talk about the last third sector. It's about specific problems. Here you might have question why these 5 blocks, why they are not part of fundamental rights. But when we were developing map, we were thinking that these questions are very deep, systematic problems which we have in Ukraine, which last for a long time and which slow down the process of Euro integration. That's why they are wider, and that's why they are highlighted here separately. Here we have social preventive mechanism, institution against which is responsible for monitoring, and it's responsible for keeping to article number 3 of convention, talking about the whole domestic violence. It's about Istanbul Convention ratified by Ukraine, and the questions of criminal code, also unfulfillment of court decisions, which is, according to the statistics, is the ECHR is the biggest problem, where there are a lot of violent decisions. Also talking about immigration policies, talking about the Schengen region, talking about IDPs, refugees, and criminal justice, which requires the reform of better guarantees of security and learning the practices of long investigations. So why these 5 questions? We wanted not to have many problems. It was important to have these questions, the requirement from EU, and also to have this for these questions to be operational, not just to know the list of problems, but receive specific recommendations and steps what has to be changed. That's why we didn't want to look at as a structural resource. Also, I would like to say that at this version of map, some topics are not mentioned. They are in the process of development. It's about religion, labor rights, talking with the new bill, and freedom of movement, right for education. They haven't been included yet in this map, but they will be placed there. And for the end, I would like to demonstrate one of those pages, if it's possible, to open the fundamental right, the right to marry.
Ось так, власне, ви можете побачити, ознайомитися з
You
інтерфейсом.
can see how this interface looks like. You can see specific law, the quote
Експерти, який підготував,
from those policy papers.
з вами відкривається сторінка.
And here you can see this page where you can read the summary mentioned by Volodymyr.
Зовсім класичним
but it's not a classical summary.
Це не
as,
виключно стислий виклад того, що
It's not just a short version of what was mentioned in policy paper, as was mentioned by Volodymyr. Also, summaries were prepared by the Center for Civil Liberties, and they are wider. They have a wider range of problems and recommendations. All summaries are in English and in Ukrainian. And lower, you can see an English version, a list of issues, and if you go down, there is a list of recommendations. And if you go down, you can see such circles. It means that the recommendation is in the process of implementation, and we also show like ticks. It means that something has been done. It was concerning the civil code concerning a right to marry. We know that in the updated, this norm was eliminated. That's why we put a tick. But talking about those realities, the process can go reverse. It can change into this mark of in the process, but we really would be happy to see those these marks, which are like ticks. So it means that it has been finished, accomplished.
Так, і відкритий зміст.
An open content. We've talked a lot about that. It would be very good if you could see it. So in the introduction, it's about some rights in the EU standards, the situation in Ukraine, how the question can be regulated, what kind of practices can be applied. In the summaries would be usually what is good, bad, and recommendations. What has to be done to harmonize the Ukrainian law with the EU. And now I will invite my colleague Timofey. Thank you.
Шановні учасники та учасниці,
Dear participants and all guests, all who have joined online, good day. My name is Timofey. I'm a lawyer of Center for Civil Liberties. I will continue our presentation. And after Volodymyr mentioned why the map exists, and Valentin mentioned why said how it works, I would like to answer the question, who is behind that and what we could do with that in future. Before we move to partners, I would like to mention what I would repeat it probably. This project was financed by the European Union, and its content is the responsibility of the Center for Civil Liberties. It's not necessarily shows the vision of the EU. It's a standardized like such legal precaution. You can see it on the websites, but it's important. EU provided resources, but didn't dictate the summaries. What you can see on the pages of policy papers or recommendations on the website of MAP is an independent position of civil society. We formed it independently based on the Ukrainian laws and EU, and MAP was developed with the support of human rights organizations, researchers, experts who were preparing the research of the European laws, and Ukrainian were preparing analytical document recommendations concerning adaptation of national laws. Among the participants are our partners, organizations, like human rights and researchers of human rights. I would like to say thank you to all who participated in development of recommendations.
Андрій Левковець,
This is Андрій Левковець, Анна Людова, Богдан Маханчук, Володимир Кобрин, Володимир Петраковський, Дар'я Расахат, Ірина Федорович, Катерина Пилипенко, Марія Грицишин, Олена Бондаренко, Олена Коваєва, Олена Сапожнікова, Ольга Кацюруба, Павло Романюк, Сніжана Шевченко, Тамара Бугаєць, Тетяна Авдєєва, Юлія Коваленко, Юлія Яремко та Яна Бюрс. Also, I would like to say thank you to the organizations and partners who participate in the development of MAP. As some have been already mentioned, this is the Association of Free Rights, Analytical Center of Pora, Helsinki Community on Human Rights, Analytical Center of Eurofam. Thank you, dear colleagues. Thank you for your contribution. Also, I would like to say thank you to the team of Center for Civil Liberties on all stages, because this project has been 1 year and a half. It was a pretty ambitious task, and I think that we managed to fulfill it on a pretty good level, and we are very grateful to our team. As it has been mentioned by Volodymyr, we invite the state agencies and scientific institutions to take part in discussion, and those recommendations, they have possibility to send their proposals, and we are ready to develop decisions for implementation. Shortly, MAP, it's a big resource, and we projected it for 4 types of users. As you can see on this screen, it's about civil society, those who work in specific areas, which you can see in the map. These are state agencies, talk about from Ministry of Justice to Office of President, international partners, and everyone who is following the reforms. Probably it's the biggest type of users, as it could be the researchers, activists, lawyers, MPs, and we invite everyone for discussion who can have an influence on recommendations in the MAP. And we would like to cooperate with the 4 categories of partners. These are the state agencies and local self-government. We suggest to develop together, not just that we demonstrate the analytics which we prepared, but the participation in discussions, common working groups. We are suggesting to work on policy papers which are available, suggest your own topics, participate in conferences,
present during our conferences. These are also civil society and human rights organizations. And if your organization has a focus on certain topic, for example, rights of people with disabilities, of children rights, or together with the experts are ready not only to give the analytics, but also to develop specific solutions to implement our recommendations. So we do not just finish our work with this presentation. We plan to work on the recommendation further. That might even result in the adoption of the law or some recommendations. So MAP is a live tool, first of all, and we hope that it will develop together with the reforms and together with your support. Thank you so much for your attention, and I give the floor to Volodymyr. Thank you. The map is an online tool that is a live tool that will get updated regularly. Each page focuses on the institution, problem, or issue that will be indicated the time of the relevance of this recommendation, and we will get this information updated on the regular basis. And that will be a tool on how we recommend the changes to be implemented. Apart from that, we understand that there might be new issues in our country on human rights, and there will be even more problems after some time. This all will be reflected in the map, and it will be reflected whether there are solutions found and the issues are resolved. So we plan to use this tool for many years, and it is not like, the presentation that is relevant at this particular moment. This work will be there for such time after the state has implemented all the recommendations. It is not like the news feed. This is not the tool to give reports on government reports or some training events. So we just state whether the state has accomplished these things or not. Maybe that is such a strict dialogue conversation with the state, but anyway, we should do that, as this tool is a kind of internal critics, and it might be impediment of the EU accession of Ukraine, but we see it the opposite way, as this tool might improve the way how things should be done without just implementation of set of events that we regularly see in some laws or events. For example, now in parallel with the EU accession, we are working on the national strategy on human rights up to 2035. So in fact, this strategy will work for the next 9 years. So where we go, which issues we are going to face in 2035. And I get disappointed by this document, as a lot of issues are not mentioned there. If we compare the problematic of the EU accession and this national strategy, they should complement each other. But a big set of problems, they are beyond the attention from the state. And I believe that is a huge issue, and we will keep on talking about that. For example, on the 27th, 28th of May, we are going to have a great conference of Euro dialogues where we will be able to take a look at the obligations from the EU side, a draft of national human rights strategy, and the plan that Ukraine has. And we will have to compare to make sure there are no problems left behind. So again, I would like to reiterate, we are not the participants of the negotiation process, so we are not aware of the process of what is happening during the negotiation. We can see only what is publicly available. We just help one side. On the one hand, we try to identify the issues. On the other hand, we try to focus on what can be done to eliminate these issues. As you know, there are problems that are here, that have been here since the 90s. And the problem, for example, when it comes to the decisions from the judges, it has been there, it is stable. Or reform of the security service of Ukraine, that was also one of the demands of the accession to the Council of Europe. So these problems have been there for 20 or 30 years. So we would like to move forward when it comes to the solutions to these problems. We can use the expertise from other countries, and also we can use other developments, but sometimes it requires a political will or a certain pressure from the civil society. That's why we would like to encourage all of you to share your feedback on this tool, as we are ready for cooperation with various groups of people. As Valentin mentioned, that tool is alive, and we still have some things to work on. For example, reform of the state services in Ukraine. We will upload the next week certain developments or materials, but also you possess certain expertise. If you see the gaps, if you know what can be added to this map, we are ready to do that, as we do not see this tool exclusively as our product and exclusively created for us. As Center for Civil Liberties is not able to implement and adapt all these reforms, so we need your support, as we should tackle the problems together when we have common understanding of what the problem is and how it should be sorted out. So this map helps us to have the common ground for understanding. And now we would like to hear the questions from your sides, if you have any questions. Maybe also questions to Alexandra Matvichuk or to three of us. If you have questions, feel free to ask.
Дякую. Чесно кажучи, питань безліч.
To be honest, I have a lot of questions. As you know, that is an acute issue and there are many problems. So I think I will raise one question, like the basic, like a question for dummies, but maybe also the most complicated question. So here we discuss how you and how we together, civil society, is trying to change the situation in human rights. What are the mechanisms that we have to influence the authorities actually, and to make sure they do what we need? Yes, that is always a difficult question, but there are certain tools, as we are a democratic country. We have certain level of cooperation with the state authorities. State bodies, they react to criticism. For example, the situation with the civil code, they prove that we have certain dialogue in the state when the issues arise. But during the research stage, we identify one more problem, that a lot of things are not happening, or they're happening because people are not aware. They are aware of the issue, for example, but they do not have complete understanding of how the problems could be solved, or they do not know the requirements that exist in the law of the EU. So we want to make sure that if even the person without legal background can understand what can be done. For example, for the elderly people not to be discriminated in our society, or what could be done for the person with disability to make sure the person can move freely around the country. And in the EU, indeed, there are a lot of policies developed and a lot of tools that help to solve these problems. And we just help in this process. So we use the tool of consultations. But again, we understand that this is one of the clusters, like fundamental cluster. And that is the first thing, and that is the last thing that is key during the negotiation process. So we have certain pressure tools for the state authorities, and we help country to do that. Taken into account, there is the state also face a lack of staff. That is a complicated issue, but I believe that for Ukraine, this is not a key question, as we still have certain dialogue And we are a democratic country where the government listens to this civil society. So I believe we'll have a lot of opportunities to influence. Any other questions? But again, I'd like to reiterate that certain thematic groups or thematic recommendations we will be discussing during the conference on the 27th, 28th of May. That will take place here in Kiev. So we will announce on Monday this big event. And then we will go into more detail. We can call it like a dialogue with stakeholders, how we should work, what should be done. Actually, we have already initiated these dialogues. For example, this year, certain dialogue on petition, on legislation, on accountability for the violent crimes, etc. In some debate for questions we already discuss with the state authorities, with the institutions involved, and we try to propose solutions. Any other questions?
Thank you. Hi, I'm sorry. I have to ask in English. My
It's
Ukrainian
okay,
is
we-
not good. I apologize. My name is Christiane. I'm with the Canadian Embassy here in Kyiv. I want to thank you for the presentation. I'm very much looking forward to dive into this map and look at what's there. My question relates to the work going on in the Rada right now with the Civil Code, and just seeing the latest draft that was dropped, I imagine you already had to amend the map, maybe, and that's going to continue. I understand there might already be some demonstrations planned by civil society in the coming days in reaction to this draft. So my question is kind of twofold. One is, will the Center for Civil Liberties be involved in organizing demonstration and debate on this thing publicly? And the second thing is for us, members of the international community in Kyiv, how can we help civil society defending human rights to advance your objectives? Of course, we have a role of, we don't interfere in the domestic affairs of a country, but at the same time, we certainly want to help Ukraine in this Euro-Atlantic integration process. And how can we be useful? Thank you.
Дякую. Так, це якраз гарний приклад української
Thank
публічної
you.
політики.
Well, that is a great example of Ukrainian public policy when the document
прав людини
actually concerns the 10th of various human rights. So it becomes the second document after the Constitution, as it has been stated by those who developed this document. And actually it creates a lot of problems. But now the biggest problem is this document that it just appeared a month ago in public space. So, we do not hurry when it comes to assessment. Together with the community, we identified the certain issues with anti-discrimination policies. There are certain issues when it comes to people with disability, with the right to property, with access to information and the liberty of speech. For example, the notion of private life is different from what is mentioned in the EU. And again, there are certain discrepancies with the freedom of speech, etc. So there are certain procedural things. We're not going to focus on them now, but we understand that the development of the Civil Code, that is a comprehensive process. So there are certain changes to be implemented until autumn. And then during autumn, we will engage in the development and the presentation of this document. So this document has been prepared by the scholars, by those engaged in civil law. And we see that this science is not aware of the European law. So those engaged to the preparation of the code and it has been discussed in the institutions. And those who have been working on that code for many years, they are not aware of the European law, or they ignore it. For example, they kept ignoring a lot of decisions that now are playing against Ukraine. So the law should have been changed to avoid these problems, but the civil code contributed to having even more problems. So that there should be a considerable, thorough legal discussion, and this code is very difficult to be assessed politically. So there should be certain balance identified by the state. For example, when it comes to children's rights, whether the state can intervene in the family life and whether there is balance of the family interest. And the EU does not regulate these things. That is an issue of the law. But when we talk about domestic violence or other forms of the violence that are there, so the code should provide certain tools that are available in the EU. And again, we cannot find this information reflected in the code. So there is a number of problems. So this code was not based on the European law. Maybe Rome law, but the civilization has changed since that time. So there should be a lot of work done. The positive thing that the dialogue is still there, but we will see how the things are in the future. As we understand that this is political process and the code is there, so we have to take a look at this code in autumn. Again, our parliamentary procedure is the following. There were many cases when during the first reading we had one draft law, but during the second reading there was another version of the document, like more positive or less positive. So the parliamentary procedure is not perfect there. It gives us certain advantages and disadvantages. But again, I believe the civil society can have certain influence on that. So we will get engaged in autumn. As I know that Mr. Stefanchuk announced that this year they are set to adopt this code, and in autumn there will be a set of discussions with Rada on human rights regarding the labor code draft, that is a serious document, and code on administrative offense.
Ще радянський кодекс про адміністративні правопорушення. Тобто, можливо, справді в цьому році ми
probably this year we will avoid all Soviet codes. But if it will be done without respect towards human beings, it could be a problem. For example, in MAP, there is a lot of what could be changed, talking about the code of administrative violations, because now how it works, it has a lot of problems concerning human rights.
Добре, чи ще є запитання?
Maybe more questions. Thank you for a very interesting presentation. I have a question concerning are there some changes in the laws of Ukraine which are better for human rights and why we don't have to adjust to the European requirements and make a step back, for example, in something what we could do better or more advanced other such cases. There is such one case where we addressed all experts who said that there is something better in the EU countries. It's the access to public information. That legislation which was adopted a few years ago and the civil code which has to be updated, but it's about those procedures which many countries do not have. So it's not a step back. Nobody forces us to decrease standards. And the standards of EU and the European Council, these are like minimum standards. We don't we know that there are countries which also violate human rights in EU. There is also their own set of human rights, and we read the report of fundamental rights agencies, which show a lot of problems in practice, which appear. That's why there are things which work well, but doesn't mean that we have to make them worse. I don't see the risk of making something worse. It's more about problem that there are a lot of questions which we need to work on, and we don't assess properly. And talking about protection of personal data, for example, EU developed system of GDPR many years ago in few phases, and we are talking about doing that after war, at the end of war. I don't understand how the system might be implemented quickly, how government is going to do it in 1 year. It's about the not understanding of this topic, because it's a problem for state agencies which work without respect to personal data. It's a problem for businesses, for organizations which work without implementation and those standards in operational process. They need to be rebuilt, and I think our government doesn't understand it properly. We have more questions which are underestimated in Ukraine, I would say. Okay, so I think at this moment we will finish this part. Now we are going to have a coffee break, and we will be prepared to discuss it privately, and we will have the second part where we will talk about reforms in the process of EU integration concerning human rights. I'm inviting you for cooperation for the next meetings and discussions of such problems, but because I think it's going to take a lot of time. We need at least 5, 7 or more years, and it's probably a positive vision, because I've been observing for a very long time how our government accomplishes some recommendations, sometimes 10, 20 years. Thank you. I hope we will have an easy and interesting discussion at coffee break.
Дякую вам дуже. Отже, я вітаю вас на другій частині нашої презентації.
Welcome to the second part of our presentation, which is going to be the discussion on the topic whether we are going to have the reforms on human rights. So I'd like to invite moderator of this meeting, Sergei Sidorenko, editor of European Truth, and Alexandra Matvichuk, head of the Center for Civil Liberties, Olga Kudishka, advisor of the Deputy Prime Minister for European and Euro-Atlantic Integration, and Roman Romanov, director of the Human Rights and Justice Program of the International Renaissance Foundation.
Він один чи... Ага, окей. Власне, у мене стоїть задача зробити
In fact, my
дискусію.
task for today is to create the discussion, not just, the presentation. So I would like to encourage everyone who is present here to get involved. Of course, we'll start with certain presentations to initiate, but if I turn my head to the audience and if I see that someone raising their hand, I will try to keep that in mind. And if we have an opportunity, I will then ask you to raise a question. So, but if I see no raised hand, then we will continue our discussion. But to begin with, I would like to talk about the fundamental things. I believe that each participant can have certain things to share about the connection between Euro integration and reforms in human rights field and discussing the situation that we have now. So I would like to ask Alexandra to start. I have the general question to you. Human rights and war, are they related? It's not that this is our, desire to somehow compare these things, but we are forced to do that, and we are in between two logics. And the logic of the war that is not correlated with the logic of the transformation. As when we talk about democratization, this is about decentralization, but when we discuss the war, so the rights are limited. And for example, we are still follow the curfew rules in our cities, but Euro integration logic and democratization logic says that we have to expand the space for the liberties. So it's not that we have to choose certain things. We have certain tasks, as we have to protect our state, our people, and our democratic choice. And the second task that we have to perform in parallel, the implementation of our democratic choice, that we have to do this here and now, given the conditions we have, as we cannot have any other. And the second, statement is that, we do not have this luxury to postpone the implementation of the democratic choice to the post-war period, because we are not aware when we are going to have this post-war, whether we are at the end of the war, at the beginning of the war. So, we cannot even predict. Maybe more countries will be involved in this conflict, in this war. So we have to act now. As you know, we do not have this privilege to postpone the changes. We have to change as a state. And the second statement that I would like to share, that was the second statement, and the third one. You know, this term, this phrase that we use, not the right time, it's not about human rights, as we have to care for our future and for our moment right now. As you know, we can keep living, having certain enthusiasm, but it's been 5 years of the war. And I read the article from the head of Azov, I think Arsen Mitrik, his name. And he stated that the main reform that is missing in the army, that is human-centered reform, because we care more about drones, about technology, and we forget about people. And we tend to forget about the basic value of the human, and reforms being human-centered, not only in the army, but in other spheres of our life. Yes, I believe the statement that we cannot wait, that we should act here and now. But talking about Euro integration, that is another question, whether our partners are ready for the actions here and now. And I also would like to ask Olga to reflect on the certain things. As now we are in a complicated situation when we have to combine the state during the war and the state being integrated in the EU, can we see the understanding of our partners and the requirements for us that somehow they should be adapted to this reality? Or are we ready to accomplish the requirement that the EU provide for the candidate states? Thank you, Sergei. To be honest, I do not like when it is stated about the requirements from the EU side. As you know, the EU as institution and member states, they have certain standard as they agreed, the standard for the member states of this community. And they expect that the countries that are set to become members of this club, that they will follow these standards. It's important to remember that they should follow the standards not only at the moment of the accession, but also when they are already members in the EU. Even if tomorrow all the agreements are signed and we become the EU members, we will still have questions regarding the human rights, and the proper institutions will be monitoring whether the legislation is aligned with the requirements, with the changes. So that is a constant process that will not stop. The same about the question regarding the rule of law. So that is not the final point. That is the process going on regularly, constantly. That is why I believe that the EU institutions, as Alexandra mentioned, we are in between two logics. The institutions are between, two wishes, two wills. The first is the understanding that this is a geopolitical question. Europe, that is bigger than the EU, they should stand with their choice, and they should be resistant to certain challenges. And if we consider this from a cultural, political, but also security union, so the desire to have Ukraine among the EU members, that is undoubtful. But there is another question, that there are certain values when the EU was created. So if the members or candidates, they might have vague understanding of the values, or there are certain inconsistencies, but they still have desire to have these values. So before the member states make sure that our legislation is aligned with these values, the practices of our institutions are aligned with these values. Before that, it would be difficult for them to take certain political decisions. That is why, on the one hand, it's a kind of a maneuver, but we also understand that the human rights issues, it's not the ground for compromises. Yeah, we can talk about certain compromises for the mechanisms, for the approaches, but in fact, value-wise, we cannot there are certain aspirations and some things where we cannot actually get compromise with. So, Roman, I would like you to reflect on the following. We state that Ukraine should prove to the partners that we should align with all these criteria. And here we are talking not only about the values. Yeah, and there are certain criteria that are not fixed when it comes to human rights. Do we feel that Ukraine is ready to show our partners, the speed of the implementation of these reforms? Thank you. I would like to start with the war. It is not impossible to not take this into account. I was very optimistic after the Revolution of Dignity, as I could see that society was ready to protect human rights and just the understanding also what this war is about. One thing when your government limits or then leads to certain resistance from the society, then it is obvious that human rights are there, that is as a desirable. But when we talk about armed aggression and the war from another country, so of course, first and foremost, these are national security interests, but that is legitimate thing to limit human rights. The question is in the following, that it does not cancel or abolish, but it can give the right for the country to limit human rights. So here we talk about the balance and how to strike the balance. How to balance human rights during the aggression. It's very difficult, and we cannot teach you or cannot train you. Of course, there is a component from the European Court of Justice, but during the loss of the territory and people during the war, and this test might not be used. So, of course, it creates this certain the certain situation for the parliament. Yeah, if there is a political will for Ukraine to become the part of the EU, we should also take political decisions.
Talking about wartime, we have to have a different vision. And I am sure that talking about question asked by Sergei, thinking about Ukrainian authorities, we don't need to have illusions. They are not always interested in consolidated. I'm not talking about champions who understand better human rights, but in general, if we talk about like decision makers' image, I'm not sure that it will be made politically, meaning the decision. We have to create picture when somebody from Europe, commissioners or European leaders or institutions can say there is a significant progress. And there is some table with some information like plus, minus. I think that the ideal picture of Euro integration is something like that, talking about Ukrainian authorities. So I don't have illusions that everyone in Ukraine will be on the same page. How the strategy is justified, nobody can give an answer. Maybe,
Але я
yes,
впевнений, що це не
but I'm
лише не в
sure that
інтересах
it's not
європейського
only
суспільства,
about the
яке
interests of
бачити
European
Україну
society
як
who would like to see
все-таки
Ukraine
основу майбутньої
as
Європи, яка
the
поділяє
foundation of
принципи і засади
European
європейського
future who
Союзу.
shares the
Але це
values
теж
and
не в
principles
інтересах
of
українського
EU.
суспільства,
But
тому
sometimes
що
it's not
тоді
always
запобіжники
about the interests of
по-перше,
Ukrainian
будуть значно менше. Якщо
people,
отут от компроміс буде
as the
занадто
compromise
глибоким.
can be too deep.
І в цьому сенсі я
In
думаю,
that
що
meaning, I
зараз
think that
це не дуже абстрактна дискусія. Ми
it's not a
дуже
pretty
шкода, що дуже
abstract
часто
discussion.
в переговорах
Unfortunately, that they treat these questions of human rights as the same as you trading something. It's about values and foundations of society. Yesterday, I had a meeting concerning civil society, concerning civil code project, and one of defenders from Azovstal, who is part of organization, he said that they were feeling that this war has two front lines. We joined defenders and on the other side, we have to resist on this lifestyle, which is not a question of compromise. And talking about the today's legislation, we can have like family relationships, so the a new project like doesn't help to do that. So it's about the inner dynamics of Ukrainian society, and now it's so quick that nobody needs to underestimate it. And I think that it gives hope in case when those squares for inclusive dialogue will happen, this dialogue will have normal, calm forms which we would like to see. If not, I'm afraid that this changes of generations, talking about human rights, it will go to more radical forms of changes inside Ukrainian society, not just about negotiations with the EU. We are talking about some fundamentals of Ukrainian society existence. We shouldn't forget what is this war about. If we see that there are orthodox elements, somebody may perceive it as a second front line, as it was mentioned by this Azovstal defender. Thank you. You started talking about some interesting framework. It was beyond those three speakers concerning war. Like you mentioned diversity of what the state has to do. It sounded in different areas. Maybe I'll ask a little bit provocative statement, but maybe it will sound naturally here. But it seems to me that it can be a subject for discussion in a wider society. How Ukrainians can talk that they are more Europeans than the very European people. In fact, in the environment of Euro-integration, this statement could be heard pretty often, because we see the survey here in Ukraine and outside Ukraine, what the treatment to LGBT, anti-Semitism, which is one of the signs of recognition. We are not at the back, we are sometimes even ahead of others. Can we say that the Ukrainians will not allow the authorities to step back from the European direction? Talking about the very principle of movement towards European values and keeping those values. Or it's wishful thinking, and we are in our level can see it, would like to see it positively.
Мені здається, що дійсно для українців дуже важить
It seems to me that it's very important for Ukrainians to have freedom, to feel freedom. And when I was thinking about that, I realized that freedom, it's not about freedom, it's such kind of value when we have to survive. 300 years we were in the shadow of the Russian Empire, and a lot of Ukrainian, a lot of people were not interested in freedom. But on the other side, I would be more modest, saying that we are more Europeans than the very Europeans, because we can give an example to confirm this statement, but it's just one part of truth. On the other side, in the Ukrainian society, there is such a vision, and sometimes I can see it, that it's the right is a privilege. These peaceful meetings should happen, but peaceful meetings of those topics we don't like, then like, oh, it's not the right time. Where could we hear that? In comments. We could hear that in research over the last 2-3 years. I didn't, concerning what Ukrainians think and understand concerning the human rights, about democratic initiatives, where they identify, say their understanding of what freedom is. And there are a lot of such discussions in focus groups. And we can see that human rights is like privilege. Only for those like who we like. And I think we should work more in that area if we want to be better than somebody else, like Europeans, so what has just been mentioned. If we talk how governmental, vertical, or horizontal levels perceive it, or on European Integration Office, is there a feeling that indeed we cannot make a step back talking about human rights, or there is a feeling that we have to push some drafts, some bills? I will say that I do not represent governmental office. I'm like advisor of the vice minister. It's not so far. Yes, territorially, no, but still. It's not a secret what we talk about when we have some internal discussions. In some way, there are some obligations, like state obligations, in order to join EU, and these are road maps. And these are pretty systematic documents. Me, as a lawyer, look at it as knowing that everything one mentioned there, by different institutions, responsible people, there are some discrepancies concerning some tasks, some like map, of course. There are a lot of different points, but still, in that list, there is nothing what concerns internal our communities, which has been discussed for many years. We never thought about that, and we didn't want. And now we see some European representatives, and they say that it has to be mentioned. So everything what has been mentioned there, it's what we've talked. But it happened that at some moment of our work, we managed to write down over points of wish list in such documents. A wish list or to-do list. At the moment when we were making it, these were like kind of wishes. At the moment it was approved, It means what we accepted. It wasn't the question of negotiations, that we could do something, on the next page we can skip something, we will know it, we will not do it. I can say that there are questions and there is no agreement in society concerning that. Maybe because we haven't reached that, we are not mature enough, maybe not many people think about that. But we remember that at one event some time ago concerning human rights, where they talked about changes to their constitution, and one researcher said that we can't rely on thoughts of majority concerning the rights of minority, because majority has to protect minority. Probably we have to move in that direction, and they are mentioned in those strategic documents. And it looks that there is an area for negotiations, and the role of civil society is very big. And during coffee break, I mentioned to Volodymyr that when a civil society will not just talk about some specific problem and advocate, but will advocate that decision, it's very, very important, because it will give a clear understanding that it could be resolved, and people spend some time to offer the solution, and government will need that support. Talking about the expertise and talking about the advocacy in order to persuade society. Maybe there will be moments when the government will have to make some maybe unpopular decisions, which will help us move forward for us as society. It's important for experts to follow, in order nobody could have a willingness to step back. Could you give an example of unpopular decisions? What do you think creates resistance in society? I will say you what it is often discussed, talking about, for example, civil partnership. For some people, it's a question not appropriate at this time, or it's not about our traditions, as people often say. They mentioned something about Rome laws. For a majority of society, people say, well, it should have been done a long time ago. For some people, it's a sensitive topic. But it looks like we will have to say the Parliament of EU that we are sorry, but maybe we will not be able to do it. So it's about internal and external cooperation. Something like that. Before I invite Roman and ask the next question, I would like to say
чимало держав, для яких ці питання, от зокрема це, також є, м'яко кажучи, не тим, до чого вони прагнуть. Ну, причому це
for many countries
сприймаються як абсолютно проєвропейські, як ті, які
for something that can be there are those who understand us, those who are the heart of Europe, I mean countries, even our friends from all Baltic countries. When we talk about partnership issues, cause a resistance in society and politics. So we are a little bit, we are Europeans talking about resistance. Roman, could you continue this topic if we talk about the Ukrainian society? As for example, representatives of Azov who were defending Azovstal. Not we as people who are in this area, but like talking about wider self, either feeling that the human rights matter for the Ukrainian population.
Я би, напевно, почав
I
відповідати
would probably start answering this question with the classics from Russian propaganda concerning Ukrainian, and that they often talk about referendum, is that we turned Ukraine into anti-Russian country, like just saying something bad. It's a very popular statement, which they know how to sell to their society, why they have to support that war, that they don't fight with them some Orthodox country. And in that meaning, we can say that our identity is about anti-Russian, talking about the absence of perception concerning about unjustified treatment, totalitarian regime. So talking about Russian political oligarchs and those who have a power, Ukraine is a threat. But we can't hear that it's something common with Europe that will disseminate in Europe. Why is it like that? It seems to me that it's very important. The characteristics of Ukrainian society is that any unfair situation causes like sharp reaction in those shapes which are unpredictable. And as soon as society participates in some topic which resonates, our authorities learned to step back because the dynamics is very unpredictable. And in that meaning, I think it's a very deep understanding of freedom and human rights. So when people are ready to protect the human rights, it's undisputable because many countries talk about that. I heard from my friends in the US after the last elections in the US that we as society turned out to be not prepared for such changes in the USA and Ukraine or Southern Korea. You are used to such changes. You have better immune system, but it's not the whole story. The human rights concerning their protection, they help society to develop this resistance, the immune system against dictatorship, but they don't give answer what's the right way. And that we are not even Europeans, and even maybe not very popular, but sometimes Russia could be closer to Europe. It's about the quality of management. It's not about their institutions are ruled by rule of law, but they can provide quality.
Even taking into account the corruption component, yes, corruption can interfere with the governance, but the international business was feeling fine in Russia, contributing to the profits that gain in that market. But they are used to the fact if there is an agreement, even if there is a corruption agreement, it should be fulfilled. So our weakness is if we have the agreement, we do not know for how long it's gonna be there, and what if we violate this agreement? Can we protect our interests here in Ukraine? And that is the huge weakness that actually make us being farther from the EU. So yeah, the work is being done partly, but the lack of the focus on governance, on institution, I believe that's the biggest problem that is brought up the list. There are certain restrictions regarding on the influence of human rights, and we would like to make sure this governance is built in the way that we take into account human rights, but I am not sure that we can bring this issue to the table when we discuss the euro integration. Let's try to be more specific. The general framework is understandable. Yes, maybe we should go into more detail. Nevertheless, there should be specific steps made to make sure we are closer to the standards that we set ourselves, that the EU expects from us, and that will help to prove that we are European community when it comes to spirit. So where is the room for improvement? I would like to restate it, and it's not like area for improvement, but these are some issues that should be sorted out. And when it comes to human rights, and we discussed that with colleagues, with Vladimir Yavorsky, and the map demonstrates that. I would like to focus on 4 topics. These are not only the things that we should change to align with the criteria and with the standards of the EU. These things also were reflected in the discussions and the decisions of the Human Rights Court and monitoring documents and law enforcement specialists. So the first I would like to identify that is fighting with discrimination. Discrimination with the focus on specific things, or just how it is defined, that is the treatment not aligned with the law based on certain indicators. And when my colleagues were presenting the map, there was discrimination, the age discrimination. Of course, we live in post-information society. So the term discrimination, that is a broad notion. We do not focus on particular components. And the next problem is the personal data protection. And when the colleagues were preparing the map, they understood that the state policy now is focused on resolving this after war. When we talk about the harmonization in this sphere, cannot be done in one day. The third topic is about the justice is non-enforcement of court decisions. And it lasts for years, and then there is failure to enforce court decisions. So there is a lack of justice. We cannot stop Russian missiles and drones. Yesterday, 22 people died. So society should feel that there is justice somewhere, and the courts, they serve as the main tool for that. And the last is the investigation of the violent crimes. So these are 4 spheres that I would like to pay attention to. I'd like to note
завдань по цим 4 сферам, але судова сфера – це взагалі окрема історія, тому що вона виокремлена у
So the court sphere, that is a separate component when it comes to requirements for Ukraine. Undoubtedly, that is an important topic. I would like to focus on other ones. As if we're gonna discuss judicial sector, that is a comprehensive topic, so let's focus on other. So do we have this room for improvement where we can have results? Unfortunately, we have to have achievements in everywhere. Yeah, sounds like a great plan. Yeah, some mundane things to mention, but it's been mentioned today that unfortunately, yeah, majority of the issues that are brought up, that are discussed, that are identified in the map that are not new to our society. They just did not appear after full-scale invasion, or these are not new challenges related to the development of AI. It's been years that we've been discussing these issues. Yeah, not only on the stage of the accession process, right? Yeah, we used to have it even before when the constitution was adopted. And we started the talks immediately that we should perform certain changes in the constitution. So the issue is the following. We understand if we identify everything as priority, there is no priority. And here is the thing here that we have to work with all the components. And we can see the process going on as Brownian motion, that the talks are taking place, the discussions are there. So we have to track the progress and to make sure that we do not miss any issues. It is obvious that officially this roadmap, these are obligations from Ukraine, but sometimes we hear feedback that the cluster is not open, so we do not have to worry about that. Yeah, the cluster is an open question. Just we have to understand whether the context and the content is there. I've heard that since we missed the deadline, we should not continue our work. Yeah, so there is no problem. So the ambitious task we have on the one hand, but without assistance from civil society, from experts, and we are grateful to our international partners that comment, that read the drafts by law, that they give the comments before the adoption of these bylaws in the parliament. I would like to say thank you for their work, but I cannot say I can see these priority spheres. Maybe we should, for example, combine certain spheres, as we should assess all the requirements, all the obligations, and the changes then should be introduced more systematically to prevent the situation when the changes are prepared by various bodies, by justice, by the Office of Prosecutor General. There is a lot of work indeed, and the Parliament pays a lot of attention to that, and Vice Prime Minister is also responsible for monitoring of the situation, and we hope that in some time we will be able to tick certain items that are accomplished in this roadmap. And the process continues. As Roman mentioned, when there is a political decision taken, we have to still understand that the work continues. And this is not just beating about the bush. We have to continue our work. There is no like final point when we, close all the human rights organization and stop work. When the political decision is taken on the EU accession, we will not be allowed, to we will have to see, actually, we will be assessed. Yeah, the monitoring will continue and there will be a constant process. Just it will be reflected in other documents. I would like to clarify, aren't there any priority tasks? Yeah, but when we say that everything is our priority, it's not a great plan. What are top priority tasks to make sure we can show the progress? Yeah, that we can perform certain tasks. Yeah, and we can say, you see, Ukraine adopted certain things, or we took. There were some changes, or we implemented. So are there any things? I think there are 10 items. These are the things that we are set to accomplish this year, these 10 points. There was an article on the 9% of accomplishment of these tasks. But these are the things, these are the points that are the part of our focus. That will help us to show the feasible result. We hope that we will perform some feasible result at the end of the year. And we know that we have accomplished certain things. Alexandra? Yes, following up on what my colleague mentioned, yeah, the priority has been identified, and personally, I do not agree with that. And even if we look at these 10 points of plan Kachka course, as we call it, as when the corruption is mentioned, but to me this is the symptom, this is like side effect of the problem. And when I mentioned various spheres, I was talking about the human rights. But for example, why there is no reform of the state of the civil servants, for example? I'm not saying that the corruption is not an important thing, but it's been identified since 2014, and it should save our country. And there are no doubts regarding that. I mean, nobody doubts this, but personally, to me, I believe it might be one of the priorities, but not the main, because corruption is the symptom, is the side effect of the problem. A great comment, thank you. Following up on the priorities and the areas for improvement, what can be done to show that not only reforms of justice or corruption topic, but what can be done to show that, you see, there is a difference between 2024 and now we have better results, we have improved certain directions. What are the priorities? I will start with the worst plan that might become realistic, actually. That is the situation when we have certain extra problems that are accumulating and we combating them, and also we see that we do not make a lot of progress. I believe that is the worst case scenario, that is the worst tactic, but that might happen actually. It took place last year when it comes to corruption. Yeah, we are all aware of the situation. So we cannot be protected. There is no guarantee for that. Even the story with the civil code, yeah, is an example. So if we do not use the European approach to non-discrimination, or when we use the notion of build that is not understandable or physical, then in the court there might be the question, there might be certain issues. Then these things might become memes and more emotional. So those responsible for the development, they meant some scientific sense, some scientific description, but then it might lead to some emotional debates that could have been avoided, that should have been resolved earlier in. I've been working in Renaissance Fund, and I was involved to many reforms and contributed to the changes in these priorities. And we also were involved in the custody record system, or also creation of some other assistance, and our work was based on the practices that existed in several European countries. There was a certain step back when we talk about this, the detention, when conscription officers are involved. Anyway, the standards that are implemented here in Ukraine, they are more advanced than in some European countries, and it has been reflected in certain mechanisms. Even now, this preventive mechanism that is used, that has been implemented with the engagement of the NGOs. So there are a lot of things that first look, they can be seen as comprehensive with the requirements of legislation, but even in Ukrainian reality, we can achieve certain results. So not to be demotivating, yeah, what can be done here.
These are only fragments of what could be done, and what has been done needs being refined. And now we need to see that there are big priority. First is to avoid additional problems. Second, I would say that I wouldn't talk about court reforms, but it's also about anti-corruption. So it's about checking the courts, and we need to find some army of honest people who have to make honest decisions, but who makes some functional analysis in court system, or just looks at the practice of local court, for example, or somewhere in some region. You will see that most of cases were not supposed to be in the court. So the task of the state was to decrease the court cases in order to have less unaccomplished decisions, and looking for not honest judges. So I think that some of the approaches have to be changed and improved. If we look over 5 systematic decisions of executive power, which cause the more arguments in the court, it's about 50% which will be decided. That's why you're talking about making list of tasks. We have to be a smart society, and we have to identify to our people and European that something works, but we still have additional work, which we would have to do it voluntarily and show that it's possible to be done. I think that we need to be more sensitive, and it's all often about the hype. If anti-corruption reform has become popular, so all questions are about anti-corruption methods of dealing with some problems, and will be the most important. And for the European representatives, it would be easier when you have some competition, and they will be checking according to this reform. But are these judges capable of providing their work on a proper level? For me, it's a problem. Thank you. So if somebody wants to ask a question, raise your hand. But I also would like to ask a question concerning Euro integration. It's enlargement report, and we talked about priorities, but EU, if we talk about reforms, identified like such 3 points. The first is to continue implementation of changes to the legislation and the protection of rights of minorities. Also, somebody added Hungarian language, and it will not disappear. Secondly, look over the legislation concerning the ombudsman according to the proper principles. Was not mentioned. And also to provide effective investigation of tortures and inappropriate treatment in the places where people are detained. Yes, we talked about in those researches, and to continue development of inclusive environment for those persons who have disability. There are a lot of details. So it looks like that EU identified priorities according to which will be assessed, and they will pay attention to them at the end of this year, and they will not refuse from them. These are those steps which are in enlargement report. And I support what has been mentioned, but I would like to pay attention that in our priorities, we set different priorities. We see European priorities in a different way than they see it. Talking about human rights, they don't mention the access to courts or anti-corruption. Everything is correct, but we can see some discrepancies of priorities. Maybe because the area is too big and we are in different locations, or what? It seems to me that we have to clarify it. We talked about some custody record or prevention mechanism. It's about human rights in the in detention centers. It's not, these are specific mechanisms which need improvement, changes, talking about national prevention mechanism. The office will be responsible for that. It's important that EU doesn't say what exactly we have to make.
Відповідності до паризьких принципів.
According to Paris principles. It's a very general statement, but we are, as a human rights organization, we have to identify for ourselves what we need, what is not enough in the effectiveness of this institution's work, what we can achieve, what it can be assessed, and how the independence of that institute can be provided. I think there are a lot of questions, and they are not so different, but our requirements are more specific than the general framework identified by the EU. And your position, maybe some insights concerning how you see if we plan those changes, which will allow EU to say next year that they can see a progress, that we have increased from 2 to 2.5, for example. As it was mentioned by Roman properly, these priorities, benchmarks, which were discovered by us recently, these are general statements which allow the European Commission and us to fulfill them. When the work is on execution of some obligations, changes of laws, at the end, it has to be about more general things. How improve the system is, how it works, how the work of ombudsman looks like.
На рівні виконавців робота здійснюється певним чином, але на рівні, наприклад, вже міжвідомчих робочих груп чи
working groups or accountability, it's about in what way those changes be reflected in those priorities or benchmarks accomplishment. The work is being done. We hope the result will be visible and we will show the results. Talking about ombudsman, yes, we had changes and there was a discussion concerning that. I think we have went through that phase so that everyone is about writing down ideal law and everything will be perfectly. I think nobody has such a vision anymore that the law cannot be perfect if you don't have a normal understanding of its appliance, so it doesn't make sense. So the question of preparing this draft bill, it's very and accepting it is very important, but it's important to understand at the very beginning, to understand what kind of problems it will resolve, how we will reinforce it, facilitate it, not just to make changes on having new words, but the practice will stay the same. And in 5 years, we will say that we need to have a new law. Because we didn't understand at the beginning what we wanted to change according to new principles. So the legislation is very important. It provides framework. But if there is no procedures, practices, and those people who will implement it properly, it will make no sense. Okay, I don't know how to make it technically.
Вітаю, колеги.
Dear colleagues, my name is Andriy. I represent a charitable foundation. I'm a veteran of the armed forces of Ukraine. I wanted to say concerning on court decisions. It's been the 7th month. I'm in the process on protecting my rights as receiving payment as a veteran. And I would like to say that the question concerning not accomplishment of court decisions is related to the central agencies with this, from the very beginning, make gaps which cause such collisions. And if we talk about practices, what happens in administrative courts, you can see that the courts are dumped with the cases from military for trying to get the financial support because military bases didn't use the proper acts from cabinet ministers of Ukraine. And it seems to me that we have to pay attention to clarifying state agencies so that we have to legislation shouldn't have so many gaps because we can't protect our rights as veterans, as military. What leads, for example, in my case, 7 months of court hearings, but I know that my colleagues have years of such court cases. And I think it's a very important question concerning the protection of human rights, in particular veterans. Thank you. Somebody else wanted to ask something.
Дуже дякую. Мене звуть Арія Мора, я представляю організацію
I represent
Advisory Group. Наш фокус
Legal Advice Group.
правосуддя
It's about
щодо найтяжчих злочинів
legislation on the crimes, war crimes. And my question will be a bit different, but we are involved to the work of many processes concerning reforms and Euro integration. And the question, and dear participants have discussed some principles, how the discussion should look like. That sometimes we need to analyze the needs and how the law has to find solutions concerning timing, but from experience and participation, we can see these problems in practice. Movement to formal accomplishment according to the roadmap. Now, through benchmarks, is a key priority. And because of that, we can see a lot of discrepancies between the formal requirement and the practical situation, in particular of context of war. In the context when we implement some provisions. And the question when we try to take part in such discussions, which are not very frequent and so inclusive as we would like to. Because of this involvement, we are informed too late and we cannot take part. Or there is some concept which cannot be changed. It's about moving forward quickly, having minimum changes, and then we will have a big problem. And when we look at reaction of international partners of EU, there is some differences because if you talk about EU, it's justified. You have to look at that benchmark, but on other side, it looks like there are other actors who are interested in meaningful changes. So if you can see such problems, can you see ways of finding solutions? Because now it looks like a train which is runs very fast, and we are like trying to figure out how to get on this train.
Дякую. Хто хотів би, я так розумію, що це не адресні обидва питання, чи репліки,
I think these two questions were not to some specific person, but these were like topics for discussion. I would comment on the last question because the first question was more like a statement what Mr. Andrew mentioned about the military, and there are a lot of other groups like other groups who have some different cases. It's a big problem. About 80% of cases in administrative courts are about not accomplishment of their obligations, financial accomplishment. I don't say that it's a tradition, but it looks like a bad situation which you see all the time. I don't know, maybe it's a tradition. It's difficult to understand. But what concerning second question, indeed, when we have to do something for tomorrow, for yesterday, but in any case, you can't sacrifice the quality. There has to be balance. If you have to slow down, let's create a working group. Then we are safe, we can relax, and nothing will happen in the next few months or even years. But we have to control that moment, not to lose the quality, because trying to make something quickly, we have seen such cases when people just like put a tick in the box and everyone else said that it's not okay, it's not what we expected. It's what you made a document and called it. It doesn't mean that you did everything properly. We had such situation. As you mentioned, if you're trying to get on train, you have to take part in different events, and from government, people have to make people involved, participate, and more inclusive, because at the end state, because it increases quality, and it shouldn't be formal. When you receive invitations and an official document, non-government organizations realize that they took part in some event they didn't know about or even expressed their support. That this kind of balance which we have to keep in mind.
Я, напевно, трошки прокоментую перший коментар, який
I'd like to comment on the first comment mentioned. As I mentioned, the judicial reform before, and I think the support from the EU is really important. Without the support, we would not be able to perform all the reforms in the judicial sector. And yeah, talking about also the resolving problems and the corruption issue is also important. But if we ask people about their personal experience of the trials, it wouldn't be on the first place, but the judicial question and non-enforcement of decision, that is another thing. I believe we can all agree that the courts are bombarded with the cases, with the files that should not be there. According to NATO standards, there is always post-assessment when it comes to military, so the detailed analysis should be performed. And that is something that is missing in the system. And I hope veterans will contribute to that. As how we can assess the court decision, how many disputes it contributed to, because there are certain decisions that could lead to to other numerous decisions in the court, and that might serve as the criteria for the assessment of the decisions. And then next time, the decisions can be taken to minimize the number of the disputes. So we cannot focus exclusively on persons in judicial system. As our heads brought this issue up, if this problem cannot be sorted out today, we can just we can transfer it to the court. It can minimize. And you know, we all suffer from this quality of this state government. Talking about corruption and problems in the judicial system, I think it's more about the corruption perception. As people face this problem and they do not consider it as a challenge in the society. So this problem is a real one, but at the same time, the perception is different. And I believe that we are moving to the closing part of our discussion. I would like also to ask, if we talk about the human rights perception in society, we can say that reforms are imposed by the EU or highlighted by the EU. It doesn't really matter if the society is not willing to perceive it as an issue. And sorry for taking on the role of the speaker rather than moderator, but if you talk about the better perception of human rights after 2014, people did not agree with the violation of human rights that took place during Maidan. And then also that is the perception from the government. So it was all about the human rights, and the society did not agree with the violation of that right. Are there any perception points now in society? What is regarded as problems when it comes to human rights? What should be sorted out? Whether it is aligned with what should be done during our accession process. Let's talk about that, and then we will come to the end of our discussion. Yeah, that is a difficult question. I understand. I'm convinced that everyone is ready to answer this question, despite being a comprehensive and difficult one. I would like to start with the simple things. War is a test, and that is our everyday test. Like what we fight for. Yeah, we do not fight only for the territories. And every day we answer this question. Talking about advancement in the human rights sphere in the last 2 years, there is not much to be proud of. We've been discussing, talking, but I was expecting what is the progress? There is no progress. It's not explained just by the fact of the war is going on. But getting back to the point you raised about the perception from the society. We talk about how things should be done. And I have colleagues from the organization. We have a lot of people residing in occupied territories, but I cannot see any movement from the state side to highlight that these are our residents living in occupied territories, that the government is willing to sort out the organization issues, the issues with documentations, and so there is a huge number of issues. When it comes to the transitional justice, we just state that Donbass is Ukraine, etc., but it is not stated legally. The next issue is justice, and I believe people can see it differently. I cannot say that we are more European than people living in Europe, but I believe that for the majority of people, even from civil society, the tool like presumption of innocence does not really matter, but it's important to bring up the topics in the public space. And human right, usually the issue of human rights we bring up when there is certain conflict. And these discussions, they can tell a lot, and they can explain why we haven't made a lot of progress in the last year and a half. So I believe this issue will be paid attention to. I'd like to be brief, and I'd like to again to reiterate on what's been said. You know, the human rights, it's like air. When there is lack of air, yeah, then the person can understand that they used to have this right and now they do not have. We talk about healthy society, yeah, when people, they do not think about rights, when they wake up in the morning and they think of what kind of rights they have. It doesn't happen this way. So we can keep on discussing, but I believe there are a lot of problems in our society due to the lack of legal culture, due to the lack of understanding of how processes are in the state, but it will not take one day to resolve it. That is a huge process that might not be taking place. But the perception of human rights as value, that is also related to this. If the rights are taken away, then discussions start, certain demonstrations or presentations, then everyone states that this is our right that should be fulfilled. And it looks like everyone felt that this is important. But 1 week ago, everyone was just living their life without thinking of that. We have a joke, yeah, that Constitution is mentioned when there is some violation. But yeah, when we talk about obligations and yeah, we forget about Constitution. So the huge part of work should be done on the raising awareness and on building awareness about the civil society perception. So this process is a complicated one. Everyone might have various perception. The perception might change with the time, and the perception of what is normal thing, what is norm for us, this perception might also change within time. So that is a constant evolution and development of how person is feeling in this kind of society. So that is a separate area for discussion, how it might be strengthened, how it should be built, and we should start with early age.
Знаєте, щодо конкретних дій, то
regarding specific actions, to make sure we transform thoughts into actions, we should have a common interest. Human rights notion is not this interest. That is a value. To make sure people are ready to protect something that is on the value level, it should be something that really brings people together. And only in that case it will contribute to shared action. Human rights is more about how to balance various interests and various groups. So the most relevant discussion now on the civil code. Yeah, but it's not just the black and white approach. There is a group of people that is demanding to keep the certain level of transparency, and they are against certain terms of like right to digital image, etc. And I believe there will be another group of people that would consider this part of values for them, especially when it comes to digital image, children, etc. Human rights should serve as an indicator balancing the various interests of various groups of people to make sure no one feels their rights are violated. That is a complicated concept. That is a certain framework within which the state and certain parts of the society should stay in. So I believe it should not be expected. It will take place only when the state government unite people with various interests. But I believe we should have better understanding of the value of human rights and why human rights are valuable and why our fight in the society should not go beyond this framework and how we should create this protection with the help of institution to make sure we have enough conversation and dialogue for everyone that following their collective or individual interest. So there is a lack of negative and, well, okay, discussion on human rights did not bring us all together. But still, we do not talk about the catastrophic exacerbation when it comes to this issue. Unfortunately, there are a lot of negative things, and now got the news about the attack on kindergarten in Sumy. And of course, if we compare it to other problems, they are less significant to this one. But talking about future and approach to the future, it should include also the things that will help to improve the situation with human rights, and the needs will also change. Thank you so much for the discussion. I hope you found it interesting, and thank you all for your participation.